My name is Lisa Macklem. I'm going to be talking about cash for content, profiting from copyright on the internet. And I think my talk should resonate a little bit with the first two presentations this afternoon as well. And I don't even have to compete with the concert now, which is nice. I don't have to worry about public performance rates. So I sort of have the problem. This is both part of a bigger project and sort of, I've identified the problem. Not so much the solution. I know that the solution is going to involve balancing of regulation policy and legislation. And exactly where that falls, I'm not exactly sure, so I'm looking forward to also getting lots of feedback, hopefully. So I'm going to talk a little bit about tensions in copyright and internet law. As we know, copyright deals with the expression fixed in a tangible medium. And one of the things that I'm really interested in is how that's affected by technology, particularly on the internet, where suddenly we don't have that tangible object we can hold in our hand. So Timothy Wu was just mentioned, and in fact I'm going to quote him when I say that new copyright law emerges from conflicts when technological incumbents and challengers come into conflict. So I'm looking at that sort of tension then in copyright and internet law, looking particularly at challenges that economics throw in, where that reward for innovation versus fostering creation finds a balance, looking at how creation and distribution come into conflict, content versus technology, the creator owner versus user, how copyright really stems from a place of using boundaries to control, whereas if we look at internet law, which of course the internet was fostered for between educational and military institutions to increase communication and foster an open environment. So there's that internet open access exchange of knowledge versus copyright, which is more of a closed system. So I'm also going to talk a little bit about net neutrality, technological neutrality, how those come into importance, and I'm going to look at three cases. Aereo, which I'm assuming most people are pretty familiar with at this point. I'm also going to talk about a Canadian case, Entertainment Software Association versus the Society of Composers, Authors, and Music Publishers, or ESA, and I'm also going to talk about a case that's also in front of the Canadian Supreme Court right now, CBC versus Sodrek, and we're still just waiting for a decision on that one. But all three of these cases talk about technological neutrality, so I'm going to briefly talk, hopefully, about all of those. So, of course, again, just to touch on the fact that copyright is trying to find that balance then between encouraging innovation, but also rewarding the creator, and those tensions that we come into contact with. And again, just to reiterate, copyright is really about creating those boundaries, how we get economic reward for our rights and so on, versus the internet, where we're looking to have an open system. So creation then versus innovation. So taking a closer look then a little bit at economics, the law, and copyright. So economics, as we know, is more than simply the study of wealth transfer. So economics is a study of human behavior, decision making, or choice. So why people behave in the way that they do behave. So if we start from the fact that people can get television basically for free, broadcast television back in the 50s, right? They didn't realize they were paying for it through advertising and so on, and then we have the introduction of cable and satellite, et cetera, et cetera. And the internet sort of starts from the same place. So people are used to getting things on their computer for free, it's all free, and then suddenly we start to see that we're going to slowly pay for it. So people need to see sort of why it is they want to pay for these things. So two of the people that I'm looking at for help in sort of unpacking the economics of this area, Posner and Schumpeter, both provide useful touchstones for looking at the intersection of technology and economics with copyright. So Schumpeter posits that economic processes are accordingly divisible into three different classes: into the processes of the circular flow, into those of development, and into those which impede the latter's undisturbed course. So Salzberger describes Schumpeter's theory as being more evolutionary than the traditional neoclassical microeconomics equilibrium paradigm. So these are things that I want to take a look at when we're looking at regulation in this sphere as well. So overregulation, Posner states, is a different kind of economic rent. It's earned by the monopolist, which we were just talking about, who creates an artificial scarcity of his product. So we're looking then to find a balance between competing interests. Posner also points out that virtually all market transactions have some uncompensated third-party effects. So this is where technology then starts to come into the equation. So we have creators of copyright, owners, and I'm particularly looking in the media sphere, and then we have technology providers such as Eric, which we're going to talk about. So copyright then is supposed to be technologically neutral. It should treat material on the internet the same way as it treats any other material. This is Murray and Trosso. Michael Geist also pointed out that copyright law should not stand in the way of technological process and potentially impede the opportunities for greater access afforded by the internet through the imposition of additional fees or restricted rules that create extra user costs. So technological neutrality then becomes a very important principle. So it refers to the principle that like technologies are used similarly by the law. And bringing again back to Posner, the differences are so great that the very term intellectual property disguises some compelling reasons for not regarding inventions, trade names, trade secrets, and expressive media such as movies and novels as property at all, but rather as sui generis fruits of mental inquiry and creation, sometimes requiring legal protection, but legal protection unlike that given to tangible property. So just taking us back to what I was saying about how moving these elements into the internet can in fact be slightly problematic. So who then is economically engaged in the litigation that we're seeing? Okay, again, this is one of those reasons why economics is underlying this entire question. It takes money to go to court. Who's going to court? It's usually a technology provider against either a collective or a content owner. So in Aereo, we saw the technology against the major content providers. So we also want to talk a little bit about technological neutrality, which is again not necessarily something you would see as being immediately obvious, or perhaps you would. Okay, so technological neutrality then is something that's been in the news both in the US and in Canada. Both the FCC and the CRTC, which would be the Canadian equivalent, have come out in strong favor of technological neutrality. So again, ISPs and telecommunication companies can exploit content owners for access to distribution, and this has a profound effect on the content that is available. So hence, this affects users and creators alike. So a recent study found that users are turning increasingly to mobile platforms, particularly for entertainment purposes over traditional computer use. For some time, traditional television and movie consumption has been disrupted by owners or consumers, turning increasingly to non-traditional means of obtaining content. So cord cutters are quickly being followed by the cord never consumer. So those consumers that have never actually had cable. So both the FCC and the CRTC have both come out and said, no, you're not allowed to throttle and charge differently for content. So I've just included a recent quote from Blaze, the chairman of the CEO. And again, just maintaining that from Trousseau, using an approach rooted in critical political economy helps to correct for some serious blind spots that, at least in the case of intellectual property and other information technology issues, results in the assumption that the public goods nature of information is a problem that needs to be cured. This cure tends to involve crafting policies that use technological measures to induce scarcity, promote rivalry and consumption, and create new exclusion and control mechanisms. So all of these result then in negative social effects. So one of the things that we want to make sure is that there's some certainty, but not that the certainty is going to have a chilling effect. So we're used to seeing technologies evolve. Courts need to sort of take a step back and then figure out whether these are actually helping or hindering creation and so on. So today's printing press doesn't look anything like the previous printing press, and of course we can take the conflict between technology and copyright all the way back to the printing press, of course, the Statute of Anne. We can also look at the evolution of copyright in the sphere if we go back to Sony, and then take that through DVRs, and then finally to the hoppers. So there's a real sort of evolution of how the courts are looking at that same technology as it evolves and challenges the rights of content owners. So, and again, the same thing with television that we received via our antenna versus television that we may receive via our computer, whether that's legally or through piracy. All right, so let's take a look at this in context then of the three cases that I wanted to talk about quickly, very quickly. The Aereo case is, I'm just going to sort of assume everybody's basically familiar with Aereo. I really just want to focus in on the technological neutrality aspect of this as opposed to the public policy, public performance right, rather. So Justice Breyer wrote the court's decision, Justice Scalia wrote the dissent. In the oral arguments, if we go back to the oral arguments, the justices were particularly interested in determining what Aereo was like, with finding the best analogy. And that's one of the things about technological neutrality that becomes the underlying concern, is are they getting it right? Okay? If they're being technologically neutral, are they really? So the court concluded that Aereo was not simply an equipment provider. They weren't just simply giving you a television antenna to use on your computer, but they were acting more analogously like a cable company. And thus, without paying retransmissions fees, they were infringing. So even during the oral arguments, the justices were told that Aereo likely did not meet the requirements of a cable company, would therefore be denied a cable retransmission license. And lo and behold, when they went to the FCC to get one, the FCC said, no, I'm sorry, you're not a cable company. So I think the takeaway for me there is that perhaps the court got it wrong, at least as far as the analogy went in the case of Aereo. The danger in this kind of decision, of course, is that it's going to have a chilling effect on other technology companies that want to sort of challenge the traditional methods of delivery. And whether that's actually helping or hindering the user at the end of the day is fairly clear. So, in the ESA case, I'm going to assume you're not all familiar with that one. The crux of the case, okay, so the winners, of course, for Aereo were the studios, the losers were Aereo and the court nevers. Unintended winners were HBO Go, CBS, and the court nevers actually ended up winning because Aereo did kind of push the studios to go over the top maybe more quickly than they were willing to. One of the other things that I also want to mention about the danger in the Aereo decision was the fact that they had to carve out things like cloud computing, even though perhaps the decision really technologically could have applied to that. So that's one of the other dangers to getting those analogies wrong, is that they can have that spread off to other technologies as well and create a chill in those sorts of industries as well. So ESA was, again, it was a 5-4 split. It was in favor of the Entertainment Software Association. SOCAN, the collective, basically wanted to double dip and collect royalties for music that they had already licensed to be done into a physical game, video game. When the games were then delivered via the internet, SOCAN came out and said, well, we get another kick at the can here because you're now reproducing the music again. In this case, the court actually sided, as I said, with ESA and said, no, it's technologically neutral here. Whether they sell the game physically or online, the result is the same. So in that case, there's more certainty as far as that technological neutrality goes. So the winners then, of course, are video gamers. So CBC versus SODREC, this is another case where the crux of the matter here is that CBC uses incidental copies in order to produce the end copy that is actually shown. The incidental copies are never sold to anybody. There's no monetary value. It's just a simple matter of creating that final product. So these are the arguments now that are before the court. So in the CBC factum, they stated there are 2 reasons why technological neutrality is central to copyright law. First, technological neutrality plays a key role in achieving the proper balance between copyright users and copyright holders. And second, it achieves a number of concrete policy objectives. Particularly in Canada, where the copyright, there's a strong policy bent towards foregrounding Canadian culture and so on, this becomes particularly important. And this is, again, just coming back to the fact that this is sort of the beginning of a larger project. I do actually want to sort of expand this out from not just North America, but look at a more global perspective on that front. So Carries-Craig states that principled recognition of copyright is requiring a sensitive public policy balance rather than simply the protection of a private property right has had a marked impact on the landscape of Canadian copyright law. So those are just 3 really very quick examples of technological neutrality coming before the courts, some of the reasons why they support it and don't support it. So potentially the winners in the CBC, hopefully will be CBC versus SODREC. So finally, just to really quickly conclude, Netflix, who seems to be getting it all right. So both net neutrality and technological neutrality can help foster better distribution of content that will in turn foster increased creation and dissemination of knowledge. So Netflix is the one that seems to be balancing it the best. So how is that? Their basic model began as an innovative DVD rental system. So we had that tangible product to deal with, okay? Owners and users alike were able to easily assess copyright within a system based on that tangible object. Netflix entered into a standard licensing agreement with content providers as their service went digital. Users could easily see the benefit to the small cost for large amounts of content. So one of the things that I posit in this universe is that it's possible that content owners are going to need to be more satisfied with a smaller slice of the pie. So they may need to actually let people like Aereo that can push the technology have a little bit of that pie as well, that economic pie. So also unlike the film and television industry, Netflix doesn't rely on the standard Nielsen ratings or advertising. In fact, those statistics are very closely guarded. So they're really pushing the boundaries in innovation. So current models then are not working when courts must surgically carve out technologies and decisions such as Aereo. Regulators and courts can both help to foster creativity and economic growth, providing a level playing field for users, producers, and technology providers through net neutrality and technological neutrality. So Craig concludes that the power of technological neutrality, quote, flows from a substantive commitment to the notion that copyright law should apply with equivalent purpose and effect across the technological landscape, end quote. So at present, it would appear that this commitment is stronger in Canada than in the US if the Supreme Court decisions are any indication. But it's really important, as I said, to be looking at the global implications of this and how cultural dissemination, knowledge dissemination, how it affects things like education, and those things. So movies may not seem that important, but I think the fact that we can all get passionate about Game of Thrones indicates that it's a universal thing that we need to be concerned about. And I would go on to talk about TPP and the economics of that as well, but I'm running out of time. So I think I have maybe 2 minutes for questions. Old technology. Right.
So, I guess as I was listening to you, it struck me that this sounds like the beginning of the discourse around sort of equal protection, right? So that the history of what counts as equal treatment suggests that agreement on what neutrality is will be hard to come by. So I wonder if you might look to the literature on, equality, so sex equality, racial equality, what equality is, because I think that will offer maybe a disappointing but important perspective on this process of selecting the right analogy, because I think you will have to have normative commitments in place before you can figure out what equality would look like.
Yes, thank you. That's a great suggestion. I haven't done that, and I definitely will.
Well, thank you.